So we've discussed a number of procedures that are involved in the eviction process. In order to have a hassle-free eviction process, we suggest that you listen to each of the videos that we've done. But most importantly, if you have questions, to contact a licensed Texas attorney. Now we're going to discuss the first appeal. Now, most evictions end in the justice courts. And landlords generally find that after filing the eviction, the tenant has left. But there are tenants who are aware of their rights. There are tenants who have been through this process numerous times before, and they know that without any cause, they are guaranteed a first appeal. The law will allow any justice court judgment to be appealed up to the county courts in the particular county where you live. Because of this, any tenant who's been evicted, even for all sorts of egregious violations of the lease, can simply file an appeal and move on to the next level. In fact, a tenant doesn't even have to show up. They can lose their case by default, never having presented a defense to the justice court. And so long as they appeal on time, they get another bite at the apple. And so it's important for you to know how to protect yourself in the event of an appeal. How do you prevent an appeal in the first place? What do you do once you get notice that an appeal has been filed? Well, we're going to talk about the appeals process now. And again, any questions you might have that you want to cover with a licensed real estate attorney are encouraged. You can reach out to us and we'd be happy to answer those questions. So first and foremost, how does a tenant appeal? Well, there are three procedures that a tenant can follow in order to appeal a ruling from a justice court, so long as that appeal is filed within the time limit established by the court, generally 5 to 6 days. Different courts kind of play with those rules a little bit. If you have a question about the number of days available in your specific case, you're free to contact the court or, again, a licensed attorney. But generally speaking, if the appeal is filed on time, there are three ways to accomplish this appeal. The first is by payment of a cash bond. Now, the courts will generally establish the bond amount at the trial. Now, depending on the amount of rent or the specific facts of your case, the court will set an amount that a tenant would have to pay in order to secure their place and to allow them to stay on the premises during the course of the appeal. Generally speaking, a cash bond is set at some multiple of the rent. If rent is established, for example, at $1,000 and a judgment is won, generally speaking, the court can set a bond at twice the amount of rent. Some courts set it higher, some courts will set it lower depending on facts. But generally speaking, a bond amount will be set at twice the amount of rent. So where rent is $1,000, a cash bond amount could reasonably be predicted to be set at $2,000. If a tenant pays that $2,000, they are allowed to stay on the premises over the course of their appeal. A second method to appeal is by way of what's called a surety bond. And a surety bond is essentially a third party, someone who has not participated as a defendant or a plaintiff in the matter. A surety will sign a document that states essentially the following: I can pay on appeal for any of the damages awarded up to 2 times either an award amount or 2 times the amount of rent. What the surety bond essentially is security for the judgment on appeal. A third party puts their neck on the line in favor of the defendant and says, whatever the costs up to a certain limit on appeal, I can cover them. So that in fact, if you win a judgment on appeal, you can collect that judgment where a surety bond is in place against the tenant or against the surety or a combination of the two. As far as the collection process goes, that's a different topic, but the surety bond allows the tenant to appeal without paying a cash bond because a third party secures the judgment. They will have to pay a filing fee, but essentially it's a low-cost method. It's, however, not the lowest cost because a tenant can file what's called an affidavit of inability to pay. Now, the affidavit of inability to pay is available to tenants who are unable to pay an appeal bond due to their financial situation. They present financial data to the court, and the court will either approve or disapprove of this method of appeal. Generally speaking, they're accepted. You are allowed to challenge them. In certain cases, we encourage the challenge. In other cases, we do not. And for specific guidance on your specific case, whether or not we would recommend it or not, again, we encourage you to contact us. Otherwise, we encourage you to contact any other real estate attorney with that specific question. Now, whether a tenant files a surety bond or they file an affidavit of inability to pay, this is the second and the third method of appeal, they make an agreement with the court to do the following. They agree to pay into the court's registry 1 month of rent within 1 week. And so if they pay, they can stay. If they fail to pay, then the landlord is entitled to a writ of possession. The matter can still go forward on appeal, but the tenant cannot maintain possession. Generally speaking, the tenant will pay and is allowed to stay throughout the course of the appeal. Their agreement goes further to say that along with paying the first amount into the court's registry, they agree month to month for as long as the appeal goes forward to pay their rent into the court's registry to allow them to stay on the premises. Now, in Harris County, the appeal process can be anywhere from 4 to 8 weeks ballpark. Sometimes it's a little shorter than 8, and so we say 4 to 8, but we've seen it go longer than 8, depending on what's going on with the courts. During the Hurricane Harvey situation, many of these dates were extended to up to 12 weeks. But generally speaking, the process is 4 to 8 weeks. Other counties go a little longer. And so while the tenant resides on the premises, they are required to pay into the court's registry 1 month's rent. That amount should be applicable to any judgment that's won on appeal at a later date. For assistance on how to recover these funds, or maybe you have judgments where amounts were paid into the registry and you'd like to get your hands on those funds. If you're entitled to them based on your position in the justice court, you'll want to consult an attorney on the proper motion to file in order for the court to release those funds. If those funds were paid and you were entitled to them but you never collected them, we recommend that you contact an attorney. Now, let's think of the time frames in these cases. Payments into the registry go, again, by agreement with the justice court. If those payments are not followed, you may have rights to evict the tenant by a writ of possession. If you have a question about that, contact an attorney. As far as additional filing fees, in the event of a cash bond or in the event of a surety bond, the tenant will be given a deadline for payment of additional fees. Their failure to pay those fees could result in a dismissal of their appeal. It's important to follow those deadlines. You should be given notice by the county regarding those deadlines. The tenant is also required to file a written answer with the court. On appeal, the process goes before the county court, and the county court is a court of record and will require that a defendant file a written answer. If they fail to file that answer, you might be eligible for a default judgment against them. The remedy for non-payment of rent into the court's registry is that a motion can be filed on your part. If there is enough time to have a hearing set in advance of trial, you might be eligible to recover possession of the property ahead of your scheduled trial. To find out if you have that eligibility, contact a local real estate attorney. And then finally, the last deadline to consider is a deadline after the trial happens on appeal. You go through the process, you present your case, and you win your judgment. What a smart attorney will do and what a good landlord will do in this situation is set what's called a supersedious bond. If you're unfamiliar with that term or unfamiliar with how to set that, contact an attorney, because that supersedious bond is usually a high bond amount that is required to be paid to the court within 10 days of that judgment. Even if the tenant appeals For a second appeal, which is rare but happens, they would have to pay that supersedious bond within that time frame. If they're unable to do it, you can still recover possession from them and remove them from the property, even if they attempt to move on with a second, much more expensive appeal on their part. And generally speaking, tenants do not pay that supersedious bond because it's so high. We like to set supersedious bonds at a super high rate, and they're allowed by the courts because we believe that it's an effective means of protecting the landlord. Again, if you have any questions about establishing a supersedious bond or any of the other deadlines that we've established or any of the method of appeal that we've discussed, give us a call, shoot us an email, or visit us online.